Good morning, friends, and my colleagues in legal profession. As a part of my series of lectures and the notes being delivered and prepared on the subject, the new criminal laws. Today's topic is the confusion and conundrum over new criminal laws, as lawyers and courts are caught in between old and new laws. It is now more than 1 month passed after new criminal laws, which denotes the Hindi hegemony with their titles BNS, BNSS and BSS came into force, which were prepared and passed to become laws under the pretext of decolonization and reforms. But in fact, everyone says that they are like old wine in the new bottle, with few cosmetic changes, giving scope for the state and police tyranny, while the soul of law remains the same. After this 1 month experience of implementation of the new criminal laws, which were pushed through the parliamentary approval in the absence of opposition and without any critical analysis and debate on them, and without placing the drafts of laws in public domain to take feedback, and more particularly from the legal fraternity and judiciary, giving government and police unfettered powers to immobilize the democracy, having potentiality to abuse and to terrorize non-violent dissent, with unlimited power to selectively arrest, detain, prosecute and convict practically anyone they choose. The government should have built a national consensus by putting these drafts of these laws for the public and for parliamentary scrutiny before passing and issuing notification, so as to completely remove all public concerns about the possible negative impact of implementation of these laws. In spite of the boastful claims of the central government, the changes effected in the new criminal laws, that these changes are neither substantial, fundamental, nor structural. For example, Bharatiya Nyaya Samhita (BNS), corresponding to the old IPC, modifies 175 of 511 IPC provisions, that is 34.24%, but most marginally repealing 22 provisions and then adding of only 8 provisions. As far as this BNS is concerned, the real change is only an addition of 8 new sections, which is 2.24% of total 350 sections. The claim of the government that the laws are Indian and totally decolonized contains is hollow. Instead, these laws contains more draconian provisions than the earlier laws. Take for example the law of sedition, which is a symbolic colonial curse, is renamed as Rajadroha or Deshadroha and enhanced the penalty from 3 years to 7 years. This is really shocking because the Honorable Apex Court passed orders in May 2022 and in October 2022 that Section 124A IPC, which deals with sedition, must be scrapped, and directed all the state and also central government not to register any case under sedition law and keep the prosecution in abeyance till the government reconsider it and scrap it from the book of law. But this came in a different form, that is Rajadroha or Deshadroha under section 150 of BNS, Bharatiya Nyaya Samhita, which is nothing but more ferocious reincarnation of sedition, which is not only violation of the Supreme Court orders but also a betrayal of the nation and intended to suppress the voice of dissent, giving high scope for state oppression when anyone, including media, speaks against the government or the truth, speaks the truth and oppose the government policies, they oppose the policies. Likewise, the provision of BNSS 2023 corresponding to Old Criminal Procedure Code, the section 187 of BNSS corresponding to the section 167 of CRPC allows the police custody beyond 15 days of the arrest up to 60 to 90 days, which is a patently unconstitutional. Section 187 subclass 2 of this BNSS permits police custody at any time during the initial 60 days for severe offences and 40 days for other offences, a radical departure from section 167 clause 2 CRPC, which stipulates that the police custody has to be sought within 15 days of the arrest. The police can't be given such wide powers which will have serious consequences leading to the custodial harassment, atrocities and torture. The power which is worse than the third degree methods, and that is nothing but a legislative terrorism. Likewise, under section 113 subclass 3 of BNSS, handcuffing of an accused is permitted, which has been held as uncivilized and inhuman and against the constitution, as held by the apex court in Sunil Batra and Prem Shankar Shukla versus Prem Shankar Shukla. This is a 1980 case. Even worse is that section 11 of BNSS allows solitary confinement of the accused in which is held to be solitary confinement allowed, which was held to be very barbaric in the same judgment. Another punishment provided under section 4 subclass F of BNSS, that is community service, like cleaning public toilets or streets, which is nothing but humiliation and against the individual dignity and liberty. Of course, there are certain good and useful provisions in VSA, which is corresponding to Indian Evidence Act and BNSS, like mandatory audio recording of police searches, audio video recording of police searches, forensic evidence collection, setting the timeline for investigation and process and the prosecution, investigation and the process. But where is the corresponding instrumental capacity, infrastructure to implement these reformative measures? Further, the government has not bestowed its attention towards pending trial cases, which runs into thousands and lakhs right from the trial court to the apex court, which may take at least another 20 to 30 years for disposal in accordance with the laws. So we will have two parallel justice systems, and the old laws and the new criminal laws as well. And the government failed to conduct any study as to the impact of the new criminal laws on the backlog cases. Within this background, the initial euphoria created by the government, that is the reaction of the court's legal fraternity after the new laws are put into practice since 1st July 2024. At a press conference, the Central Home Minister on 1/7/2024 proudly declared that every aspect of the new laws has been discussed extensively with the different stakeholders for 4 years, and no law in independent India has been discussed at such length. This is absolutely a wrong statement. He further said, if the date of crime is before July 1st, then it will be tried under the old laws, and if it is later, it will be tried under the new laws. But the confusion continued and the uncertainty persists about the legal framework with which is applicable and when and how in the cases, because of different stages of the case occurred before and the transition from the old to new criminal laws on July 1st. Let us take a situation where a heinous crime is committed on 30th June 2024, but complaint was given after 1st July 2024. In such a situation, which criminal legislation applies? What happens when there is a gap between commission of offence prior to 30th June or on 30th June 30th and the registration of the crime on July 1st, 2024 or thereafter? This confusion has raised different views and interpretations in the judiciary and legal fraternity as well. Let us look at the repeal provisions of IPC as per section 358 of BNS, which states that notwithstanding the repeal of the IPC, such repeal shall not affect the previous operation of the IPC or anything duly done or suffered thereunder. Consequently, IPC would be applicable for the acts committed prior to 12 hours midnight on 1/7/2024. Likewise, section 531 of BNSS says that the CRPC stands repealed, and notwithstanding the repeal, if there is any appeal, application, trial or inquiry or investigation pending, then such appeal or application or trial or inquiry or investigation shall be disposed of, continued, held or made, as the case may be, in accordance with the CRPC, as in force immediately before the commencement of BNSS. In ordinary course, an act of repealing statute or deleting a provision is to obliterate it from the statute book as completely as if it had never been passed, and must be considered as a law that never existed. This legal position was reiterated by the Apex Court in Radhapur Concern Works versus Union of India. Conversely, we cannot say that an offence registered after July 1st, 2024 but committed before such date would be under BNS, since as on the date of commission of the offence, the BNS did not exist. Thus, the blanket interpretation that only the new criminal laws will apply in such a situation where a crime is reported on July 1st, 2024 or thereafter cannot be sustained. Article 20, Clause 1 of the Constitution of India clearly states that no person shall be convicted of any offence except for violation of the law in force at the time of commission of that act charged as an offence. Thus, a person cannot be said to be guilty of an offence under BNS which was not in existence at the time of commission of offence. Then, what would be the possible course? The offence of committed earlier to July 1st, 2024 would attract the provisions under IPC and would be registered under BNSS when repeated on or after 1st July 2024. Thus, invariably there will be a coexistence of IPC and BNS and BNSS and CRPC. In such a situation, we find support to this position in section 4(1) of BNSS itself, which states that all offences under any other law shall be investigated, inquired into, tried and otherwise dealt with according to the same provisions, that is the provisions of BNSS, though it can be argued that any other law could include the provisions of IPC or CRPC which were in force prior to July 1st, 2024. Apart from these ambiguity and confusion and contradictions, the recent observations and interpretations or orders by different high courts on the applicability of old or new provisions of acts and procedure further compounded the legal fraternity and the courts as well. And the lawyers who are caught in between these two contradictions are forced to protest against these new laws. In fact, on 19/7/2024, the Madras High Court questioned the very need to bring new criminal laws with only cosmetic changes in the old laws and instead of amending the existing IPC, CRPC or Indian Evidence Act to bring the present changes. While hearing bills filed challenging this constitutional validity of these new three criminal laws, BNS, BNSS and BSA, the court also expressed dissatisfaction for not considering the views of the Law Commission and opinion of the Parliament. On July 9th, Rajasthan High Court, that is Justice Arun Mangia, ruled that if FIR for the crime had been filed before July 1st, that is, the investigation and the trial would have to follow the old CRPC, even if the investigation and trial commences after July 1st. 2 days later, Punjab and Haryana High Court relying on the language in section 358 and section 531 of BNSS held that once BNSS brought into existence and into effect, it would apply to the offences committed under IPC, thus recognizing that the IPC can continue to be the substantive criminal law, while BNSS is the new procedural criminal law. It further held that even if FIR was lodged before July 1st, any court application or petition relating to it is filed on or before July 1st, then the filing shall have to be done under BNSS. Further, the Chief Justice of Punjab and Haryana High Court issued a circular stating that the fresh cases could be filed in high courts under both new or the old criminal laws, and the court rightfully could not object to it. Both these decisions of Punjab and Haryana High Court are inconsistent with each other, although the circular issued by the Chief Justice of a court will carry greater strength than an order passed by a single judge. On 12th July 2024, Delhi High Court, the Justice A.J. Ambani ordered in similar questions and ruled that in an FIR filed under old criminal laws, the bail application filed or on after July 1st will have to be filed and governed by BNSS only. Simultaneously, if in a separate ruling, he decided that if an appeal in a criminal matter was pending before the court prior to July 1st, it would be continued to be governed by the old CRPC. But if the appeal is filed after July 1st, it would be governed by BNSS, even if the trial was conducted and completed under old CRPC. At the same time, he refused to declare them this order passed by him as an authoritative interpretation of the question and left it open to be decided in the future. Likewise, Kerala High Court, Justice P.G. Abhijit Kumar, in an order, referred to and endorsed the interpretation given by the Justice Goyal of Punjab Haryana High Court. Thus, the situation has become a chaotic and total mess as a consequence of poorly drafted laws without wider consultations and with all stakeholders and the parliament scrutiny. Now, all the lawyers are dependent on individual judges in respect of the applicability and provisions of new laws, and how this will play and impact the cases remains to be seen. This may also lead to increased litigation if someone don't agree with a particular interpretation by a high court and may appeal against it. This uncertainty and confusion could have been anticipated and prepared for by the government before rushing through this legislation. Even now, it is not too late. For the government to rectify the blunders by putting these acts before all the stakeholders and Parliament for detailed scrutiny, for a wider debate, and make necessary changes in tune with the constitutional mandate. That should not be forgotten. Instead of taking it as a prestige issue and reject the genuine apprehensions raised and voiced by the opposition, legal communities and judiciary. More so, when the constitutional validity of these laws is under the scrutiny of Supreme Court and before various high courts, to avoid any embarrassment to the government of getting these laws declared as unconstitutional and undemocratic, as in the case of farm laws, ultimately which were forced to be withdrawn by the government, due to widespread opposition and resistance by the farmers. So in this regard, my suggestion and also advice and request to the government is, please kindly put these laws, new criminal laws, and there is no need to name them like that, because nobody can understand. India is a pluralistic society having many languages. So Sanskritization of criminal laws or names, this is not acceptable according to the constitution. In fact, as per the law, the language of the courts is English. So what is there with their names? So we are not able to even pronounce them properly. So that factor also should be taken into consideration, because this gives impression that they are imposing the Hindi hegemony on the other parts of the country as well. That misimpression should have been avoided. Therefore, it is in the earnest of things that I request the central government to again place these things before the Parliament for detailed scrutiny, and also elicit the opinions from the bar associations and other legal experts, and also from public domain, and make necessary changes, because under the guise of decolonization, under the guise of reforms, the new criminal laws in fact have become more draconian than the earlier laws. So it is high time to rectify all these mistakes, and I hope my brothers and sisters in the legal fraternity will agree with my views, and let us all bring pressure on the government to modify or amend these new laws which are in force now. Thank you very much. ఇది పెట్టింటే ఆ మాటలు